Hi, everyone. Just waiting for everyone to connect, then we'll begin. And just a reminder, if you could just mute yourselves until later on if you wanted to ask a question, please.
Okay. I'm Aparajita Sharma from India.
Hello.
Hi. I just wanted to listen to you.
Lovely. Thanks for joining.
Thanks.
Okay. Hi, everybody. Thank you all for joining us today for the first webinar in the UNDRIP series, United Nations Declaration on the Rights of Indigenous Peoples, in partnership with Diplomacy Training Program and Oxfam Australia. Before I start, I'd just like to acknowledge country. So I'm calling in from the lands of the Bunurong people of the Kulin Nation in Melbourne, Australia. And just want to pay my respects to their elders, past and present, and also extend that acknowledgement to all of the various countries that you're calling in from today, as well as all of your old people that you bring with you wherever you go. My name is Taina Tihemara. I'm a alumna of DTP from WA, Maimoba Ngalama and Injimarndi from the Pilbara, and Tiatiao Ngatiroka from Aotearoa. It's a pleasure to have you all here today. We have two fabulous trainers, Les Malezer and Monica Morgan, who I'll introduce a little more further down. But I'd like to pass it over to Patrick Earl to give a bit of a background. Patrick's the Executive Director of the Diplomacy Training Program. Thanks, Patrick.
Thank you very much, Taina. I'm joining you from the lands of the Bidjigal people of the Eora Nation, from the DTP offices in the Faculty of Law and Justice at the University of New South Wales. And I begin by acknowledging the traditional owners of the land that we're on and their long struggles for self-determination, which is the focus of our discussions here today. The Diplomacy Training Program is a small NGO established by President José Ramos Horta of Timor-Leste and Professor Garth Netheim, the late Professor Garth Netheim, and is committed to building knowledge, skills, networks around human rights. And I would like to begin also by acknowledging the traditional elders, past and present, who are joining us here today, to pay my thanks to Oxfam, our partner in this program of webinars, and also to the Swiss Embassy in Canberra and to Dale and Fabienne, who've been very helpful in supporting this work to date, and who've been encouraging us to organise a series of webinars and helped us last year in hosting a roundtable of our alumni and our partners to re-establish DTP's work on building knowledge, skills, understanding of Indigenous people's rights, right to self-determination. The outcome of that roundtable last year was a strong sense for the need for building knowledge and understanding of internationally recognised rights. And so this series, at least of 3 webinars focused on the UNDRIP, begins today. And we're really grateful for the expertise and knowledge participation of Les Malezer, who's been a trainer on our programs before and who's known to many people here in Australia and internationally for his work in elaborating the rights of Indigenous peoples and right to self-determination, and also to Monica Morgan, who we're proud to call an alumna of the Diplomacy Training Program too. So we're looking forward to a very good discussion. Thank you very much, Taina, for taking on the role of host and facilitator. And the spirit in which we hold this is of creating a safe learning space based on respect for human dignity and sharing of knowledge and experience. So we're looking forward to sharing knowledge together and to learning together and thinking about how we can contribute to progressing the realisation of rights. Thanks very much.
Thanks, Patrick. And just before we go over to Les, just a little bit of housekeeping. If you have some questions, you can just chuck them in the chat box. And as Les goes through his presentation, there'll be some opportunities to ask questions. So thank you, Les, for joining us today. It's a real honour to have you here and to learn from you. As Patrick said, you've been involved in the space for many years, and a historic involvement at that. So Les has dedicated his life to promoting and defending the rights of Indigenous people in Australia and internationally, and he played a significant role in the development and adoption of the United Nations Declaration on the Rights of Indigenous Peoples. So I'll pass over to you, Les, to introduce yourself and begin your conversation. Thanks, Les.
Thanks very much, Tina. I understand that this is viewed to be training for people who want to find out more about the Declaration, and that it will be part of a series. So I'm hoping to deal with some of the big issues. I think the most important issues around the Declaration on the Rights of Indigenous Peoples, and that there will be opportunities, I think, for people to delve more into some of the areas. It's a lot of ground to cover, you know, 1 hour webinar, and I think we'd all like to see that we can put 30 minutes aside to take questions and answers. And also I will probably have about 3 or 4 pauses through my prepared presentation, at which time there'll be opportunity, I think, for me to get some feedback with a question or two. So from the audience, the people who are there, as Tina said, if you have a question, throw that forward, or Tina herself might ask me to elaborate on something that I've said in there. So let me start with by saying how important this declaration is. And even I haven't realised exactly what impact it's having around the place. But it is very, very important. First off, I want to say that adopted in 2007, the Declaration has and will continue to have significant impact upon international law regarding the Indigenous peoples of the world. And the international law is so important because later on you'll hear more about reluctance of states to take the step, the commitment to doing certain actions. And this is where I think the bringing it into international discussion is going to be, I think, a big part of how Indigenous peoples are able to utilise the Declaration. And of course, international law is developing because Indigenous peoples only technically became identifiable in international law as a peoples in 2007, when the Declaration was formally adopted by the General Assembly. And so there's a lot of work going on at the moment to try and clarify. I know a lot of states want to know, who are Indigenous peoples? How do we identify them? And the other question is, what is the right of self-determination that they have? Is it the same that states have? All peoples have the right to self-determination, or is it something different? I will clarify on that. And it's an instrument that evolved from the work from Indigenous peoples. We were the ones, as the intended beneficiaries for a human rights standard, that put in the hard work to get this brought to attention at the international level. It took almost 100 years, or in fact, took just over 100 years of international lobbying by delegates of Indigenous peoples to get the Declaration finally established at the United Nations General Assembly. The initial references to which I look are the delegations that approached the League of Nations back in the 1920s to try and get opportunity to speak on the floor, to talk about how their rights were being violated by the dominant society. And although a declaration is a non-binding instrument, and we will constantly be reminded of this by states, it's not binding upon them, the declaration is actually founded on principles which appear in the United Nations Charter and is also well contained in international treaties that most states that sign on for human rights have responded to, and particularly the Covenant on Economic and Social Cultural Rights and the Covenant on Civil and Political Rights, which are seen to be part of the Bill of Rights at international law. And the Declaration is backed by many additional instruments calling for cooperation and partnership between states and Indigenous peoples at domestic levels. And you'll get a little bit more on this later on, but every year there are resolutions coming out of the General Assembly, out of the Human Rights Council, out of treaty bodies, out of special mechanisms on human rights, talking about Indigenous peoples and what needs to be done. So since 2007, it has become a much referred to topic on human rights. And of course, anyone dealing with human rights in a state, country that has an Indigenous population will inevitably be challenged in relation to what their relationship is with the Indigenous peoples by the international human rights mechanisms. Sovereignty is an issue that comes up in Australia and no doubt comes up in many places. And sovereignty is valid, and there is a relationship between sovereignty and self-determination. But it's a difficult concept to use and argue when trying to talk about human rights, because it's not really founded in international law on platforms like self-determination is. So in my work, I've always referred to self-determination in lieu of sovereignty, although sometimes it slips into the conversation. But as I said, in terms of building a platform on talking about rights and seeing that those rights are able to be exercised, self-determination does provide those steps on that platform. So let me give you then a view of what are the features of the Declaration. Claire, I'll ask you if you put up that first screen for us. So the Declaration does these things. It addresses collective rights of peoples in international law, the rights of peoples. Most human rights law is based about the rights of the individual, and not much development has occurred in relation to collective rights, because generally states have been tasked with the obligation to see that the populations within their territories are able to enjoy human rights. And so it doesn't require, I think, legal argument to be developed as to why particular populations require self-determination, and in this case, Indigenous peoples. Every time I've researched self-determination, what does it mean? It keeps on referring back to Indigenous peoples' right to self-determination. So collective rights is what the Declaration's all about. As far as individuals go, the body of law on rights of individuals is there, starting with the Universal Declaration on Human Rights and many, many other human rights standards that have been developed from that point. The Declaration doesn't create any new rights, but it simply cites fundamental rights which have been denied to Indigenous peoples. So the Declaration doesn't set out in its adoption by the General Assembly to create a new right or establish something that wasn't already in existence. And the Declaration features, amongst many other things, I'm highlighting here the main things as you see on the screen, rights to self-determination, lands, territories and resources, governance and autonomy, and obligations of states. And again, I say these are the sorts of things that were denied to Indigenous peoples historically, from the time of having their territories colonised and being subjugated in various ways in the main population and so on. These are the key things that we have fought for at the United Nations level. And the Declaration, I think it's important to know, is supplemented by the outcome document adopted in 2014 at the General Assembly. So 7 years after the Declaration was adopted, the General Assembly called a high-level meeting of the General Assembly and called it the World Conference on Indigenous Peoples for 2 or 3 days. And they adopted another resolution, this time unanimously. It was by consensus. And it was more or less an action statement to implement the Declaration. So I'll make further reference near the end of the presentation to say that there is an action plan to see that the declaration is implemented, adopted by the General Assembly. So it is just as valid and it is just as important as the declaration itself. So the two documents, the two resolutions of the General Assembly, one in 2007, the other one in 2014, need to be read in conjunction with each other. And also, I'll just remind you that this is the 10th anniversary since that World Conference on Indigenous Peoples was held at the General Assembly. And I think there'll be more reminders happening around the world about the 10th anniversary, and seeing that more action should be happening around the world. And self-determination, expressed mainly in Article 3 of the Declaration, reflects the wording in Article 1 of the two covenants, and I'll show you that later on. And the Human Rights Council and the Committee on the Economic and Social and Cultural Rights, which are the two bodies administering the two covenants, the two treaties signed by countries, have expanded their comments on Article 1 about self-determination to incorporate Indigenous peoples' interests into there. We're urging them to do more in terms of Article 1 of their covenants, because those two treaties are legally binding upon states that have ratified them. So while the declaration might not have a legally binding aspect to it, those two treaties do, and self-determination is clearly articulated in Article 1 of each of those covenants. And I've already mentioned that the declaration is supplemented by the outcome document. Now, the declaration itself, as a body of work of 46 different articles, can be considered to be a roadmap for self-determination of Indigenous peoples. And it's on the lines that if the rights that are expressed in the Declaration on the Rights of Indigenous Peoples are being respected, then self-determination can be deemed to be exercised. So that's an interesting test, because one of the things that's happening, I think, is the legal questions are being asked: how do we incorporate self-determination into domestic law? And how do we do that? And there's the answer. That's the first answer, is to say, if the other rights are being implemented, then it should be adjudged that self-determination is being exercised. Some states seem to be trying to redefine self-determination as a limited right, limited to be controlled by the states. But there's no such restriction implied in human rights to self-determination of all peoples. So I see this in some definitions being floated, that it's an internal thing, and meanwhile the state still controls the Indigenous peoples in terms of matters external. But that is not the case. It's a definition that's wrong in law, and which states are trying to get away with in downsizing what it's about. And it's taking too long for the states to embody human rights for Indigenous peoples into domestic laws. And more recent examinations at the UN are becoming more focused on the need to implement the right to self-determination of the Declaration in total through legislative and executive actions. Executive actions of governments are those things where they create programs and they can do other things policy-wise and program-wise. It's not just legislation, although the treaty bodies say they would prefer if self-determination is protected in legislation, not just in executive action. And my final comment in terms of introducing the Declaration is that Indigenous peoples at the national level should make greater efforts, and I'll even go up to say must make greater efforts to organise and take control of the need for change, because change is not happening, certainly not at the pace that it should be happening. And states, generally speaking, are falling short of making real commitment to what is equality and human rights where Indigenous peoples are involved. So it's a case of, again, we're being left behind as states focus upon their human rights obligations. They keep on leaving Indigenous peoples down, left behind, or in the shadows in terms of those issues. Now, so let's take those 4 points that we see there: self-determination, Claire, I might ask you to go to the next screen on that. I'll probably just go back a page here. So the first question, if all peoples have the right to self-determination, and that's from the UN Charter and the treaty bodies, who are peoples? And that's a question that comes up, who are peoples? I'll go to the next screen then, thanks, Claire. And generally, peoples can be described as being populations who are organised polities. Now, it's a word I didn't know before, and I'm sure most people don't know it, but polities are basically where there's some structure of organisation, where they have a collective identity, where they have political workings and even legal workings happening within the groups. Of course, states are regarded as being polities, and I'll say a little bit more about states in the next slide, but polities do not necessarily need to be governments. A polity is a group of people with collective identity who are organised by some form of political, institutionalised social relations and have a capacity to mobilise resources. Interestingly, this is a bit of an aside, a corporation can be a polity if it's capable of marshalling resources, has governance structures, legal rights, and exclusive jurisdiction over internal decision-making. And we might even say there that we're experiencing where international corporations are functioning equivalent to states, and in some cases, in fact, able to take states to court over matters and so on. So a corporation can be a polity. An ethnic community could be a polity if they have sufficient organisation and cohesive interests that can be furthered by their organisations. That doesn't say that ethnic communities have a right to self-determination, because one of the things that was clear in negotiating the declarations is that Indigenous peoples were particularly unique because Indigenous peoples had basically the standing as a polity and institutional arrangements before colonisation. And those things have continued, even though they've been damaged, weakened, and so on, under colonial rule and dominance by major societies, loss of territories. It is a self-determination is a function that basically can be applied to those Indigenous populations in the modern era based upon the sort of structuring that Indigenous populations have. So it'll be a question that'll come up over and over again, but basically self-determination is the keystone to all this. Claire, I might go to the next slide. And I just say here that talking about states as a polity and as a body which holds the right to self-determination, that goes back to the convention in 1933 known as the Montevideo Convention on Rights and Duties of States. And in Article 1, it says the state as a person of international law, that is, they have a status in international law, should possess the following qualifications: a permanent population, a defined territory, government, and a capacity to enter into relations with other states. So that's the general rule that continues to apply in law nowadays about if a new state is formed through any process, they are the ingredients that would be considered to be the ingredients required for a state. So to give an example, Palestine's been proposed as a second state in the region of Europe. Does it have a permanent population? Yes. Does it have defined territory? Yes. Does it have a government? Yes. And does it have a capacity to enter relations with other states? Yes. So they meet that criteria. They just have to be considered by other states to be to have statehood and to be joining as member states. And that's the matter that's in process. I'll go to the next slide. Thanks, Claire. Right. So in the declaration, Article 3 says Indigenous peoples have the right to self-determination. By virtue of a right, they freely determine their political status and freely pursue their economic, social, and cultural development. And that's what Article 1 in the covenants both say in Article 1, those same words. So there's no difference between what's said in the declaration, what's said in those treaties. And that is what I'm emphasizing to say, is that those covenants, those treaties that have been signed onto are designed to protect the rights of Indigenous peoples under Article 1. Now, the other two paragraphs weren't included in the Declaration on the Rights of Indigenous Peoples because they slightly refer to other matters which are state related. But some of that, like freely dispose of natural wealth, does come up in the Declaration elsewhere, and I'll come to that a little bit later on. So just to be aware that there's no difference between all people's right to self-determination and Indigenous people's right to self-determination, and we can pursue that through existing treaties. We don't have to get domestic approval to be identified as peoples. What we can do, and that's one of the things that I will be doing, is I'll be saying, why aren't you making comment on us as Indigenous peoples when you consider Australia's human rights report under your treaty? You know, why are you downplaying our ability to have self-determination in that? So this goes back to why I'm saying the development in international law is at a rapid rate, and it is really, really important that Indigenous peoples work that over, not just their domestic governments. Claire, I'm not sure if the next slide has another thing on. Can I see that? Page 7? Oh, that's it, page 6. Yes, sorry. So talking now about self-determination, I'm looking at 3 of the particular articles. Article 3 we've already looked at, but note there it says, by virtue of the right, they fully determine their political status, right? So I would think that in most countries with Indigenous populations, their political status has never been freely determined by the Indigenous peoples themselves. They've been basically either denied rights of other citizens or being given only the rights as they apply to other citizens, that is assimilated into those, rather than allowing Indigenous peoples to decide and define what their political status is. And also that includes, as self-determination, the ability to develop economic, social and cultural rights. So, and that doesn't come up in discussions either about economic, social and cultural development. And then the next article, Article 4, says in exercising self-determination, they have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means to finance the autonomous functions. So the ability to have the resource, the ability to have the means, the expertise and so on is a part of self-determination. So it's one thing to talk about autonomy or self-government, but it also can't happen if it's separated from the resources needed. And Indigenous peoples in Article 5 have the right to maintain and strengthen their distinct political, legal, economic, social and cultural institutions while retaining the right to participate fully if they so choose in the political, economic, social and cultural life of the state. It's a very, very important one to remember, that people can exercise autonomous functioning of self-determination and choose to participate fully in the life of the state. And that's something that's happened in the Cook Islands. If you ever get a chance to look at there, as a territory of New Zealand, they were given the opportunity to become independent as a state or to remain in a relationship with New Zealand. And they decided, I think wisely in their case, to continue to remain as a part of New Zealand, but to have autonomy in relation to their matters of governance in the community, but have New Zealand take care of some of the bigger pictures that they have in terms of like trade and development and so on, where the country has a bigger operation on which they can continue to mount. Now I might come back to screen to me. Thank you, Claire. I'll just see what my the next topic that I'm going to go on to is about lands, territories and resources. And but before I go on to that, I'll take that break and see if there's one or two questions that have been raised in people's minds. Dana, do you?
I can't see any questions if nobody has any questions.
Okay.
Just letting you know, Liz, it's 4:37. So maybe after this section, it might be appropriate and useful to bring in Monica to have a yarn with you about the topic.
Yeah. Okay, I'll go through the rest of it just very quickly. I won't elaborate. I'll just go slide by slide. Okay, so let's go to lands, territories and resources. I'm here I'm just citing the various articles that to get you interested to look at everything, because I'm just picking out, I think, the ones that I think will speak to you most. So Claire, if we can go to that next slide. Okay, so you see I've cited there Articles 26, 27 and 28. You'll find that Articles 25 to 30 deal with lands and so on. So basically it says right to own, use, develop and control the lands, to have a fair, independent, partial, open and transparent process to adjudicate the rights to their lands, territories, and also have the right to redress, restitution or compensation for lands which have been taken, used, damaged without their consent. So that gives you the element of the rights on lands, territories and resources. Both self-determination and lands, territories and resources were the two key points holding up the declaration over the last few years, and were the areas where, after the declaration draft had been adopted at the Human Rights Council, there was still an attempt to try and wind back some of these provisions, but they were maintained into the final document. I'll go to the next slide, which will be on governance and autonomy. So Indigenous peoples in exercising self-determination have a right to autonomy or government, as well as the ways and means for financing it. We've looked at that before. Other ones that deal with autonomy, Indigenous peoples have the right to establish and control their educational systems, Article 14, maintain and develop decision-making systems, Article 18, develop their own political, economic and social systems, Article 20, determine their own priorities and strategies for development, Articles 23, and also in Article 32. So you can see clearly there's messages there about the governance that Indigenous peoples can be having and the autonomy from state control in that. And the next slide is on the obligations of state. And the important one, there's 3 different articles in the declaration, Article 20, Article 39, Article 40. I've extracted from each of those. Indigenous peoples have the right to access to and prompt decisions through just and fair procedures for the resolution of conflicts and disputes with states or other parties, right? So it's making it clear there that that's a right, is to have resolution of disputes promptly and through a fair process. At the moment, it's one-sided because it's the states and the courts of the states that are making decisions about Indigenous peoples over disputes. Article 20 talks about just and fair redress. So Indigenous peoples deprived of their means of subsistence and development are entitled to redress for that. So if Indigenous peoples are poor, as most Indigenous populations are, they don't have the means. They don't have the means for their self-governance. They don't have the means for their development. And that should be immediately overcome through fair redress for being denied those means. And Indigenous peoples have the right and access to financial and technical assistance from states and through international cooperation for the enjoyment of rights contained in the Declaration. So that brings in this element of where Indigenous peoples also can enjoy international support. If we go to the next slide there, it also talks about preambular paragraphs. So read the preambular paragraphs, because generally before the articles which state the right, preambular paragraphs generally state the facts on which the rights are developed. And if you look at those, one I've put in 6, 9, 20 and 14. I won't go through those, but you will be able to access these documents if you contact the organisers of the webinar. And on to the next slide is I've given further reading where General Assembly and the Human Rights Council have passed resolutions, particularly in the last year. I'm very, very impressed with what the General Assembly passed in September of last year on the rights of Indigenous peoples, quite detailed and quite emphatic about states should be meeting their obligations. And also the Human Rights Council, which passed theirs in 11th of October 2023, is also emphatic and proposing. The Human Rights Council, in fact, is going to have a special session this year to say why the declaration is not being implemented and how the implementation of the self-determination needs to be monitored. And then below that, I've listed some other articles that if you get the time and inclination, you can go and read more important documentation which expand on the things that I've been telling you about this. And that's just a small example of what's out there in the international community, and particularly the United Nations that's happening on the right to self-determination. So that does complete my presentation. I'm sorry to have taken up a bit of time, but I'll go back to you, Dinah. Thank you.
Thanks so much, Les. I know we've asked you to do an enormous task in a very short amount of time, and you've done an excellent job. Thank you. I might invite Monica in to come and have a conversation with yourself, Les, and we've also got a couple of questions in the chat that perhaps the both of you could talk about. So Monica Morgan is a Yorta Yorta woman and activist who has decades of experience in promoting and claiming the right to self-determination. Thank you, Monica.
Thank you very much, Diana. And Les, thank you, as always, very informative. I've known Les since we were teenagers, well, not teenagers, but young people. And he's always had an enormous scope for fighting for the rights of our people. And I really thank you, Les, for all the work that you've done. One of the things that I'd like to see as a part of the end of this for everyone to see is what exactly Les, a kind of biography, I suppose, of Les's work. It's been over many decades in United Nations and promoting, and also promoting on the ground amongst our own people. So I thank you very much, Les.
Thank you very much, Monica.
And I'm very proud and privileged to be here with you.
Thank you. Thank you.
Look, you've done a lot of the work on the world stage, and you've done a lot of the work IPO, Indigenous Peoples Organisation beforehand, and and represented us in the Pacific and represented us, in very many levels. What are the key things that you would like our audience to understand in relation to how complex and how long the struggle's been, and where is your kind of thought on what is the pressing needs that are in place, at this moment, particularly in this country?
Thank you, Monica. It's a really good question in the sense that after the Declaration was adopted in 2007, I took the decision that my work at the international level is finished. It's now important to see things happen in the state. I'll go back and focus on Australia. And at that time, I stood to become co-chair of the National Congress of Australia's First People and was elected for 2 terms in there, and tried through this national representative body to get the state to get into dialogue to try and advance the declaration in Australia. That's been very, very difficult. It's been a brick wall in that sense. But this year, next month, we're going to get a report from the Parliamentary Joint Committee on Human Rights about a human rights charter in Australia. And so I'm hoping that I can get a message across there to say, deal with the rights of Indigenous peoples first, because we've been sitting around for over 220 years, with our rights denied to us, shouldn't this be a priority? And if you don't deal with it, then aren't we being left behind, as usually happens in the case when people are talking about advancing rights and progress and development and so on, we're left behind. So, and that I did emphasize in my presentation that really, I think the energy has to come from Indigenous peoples themselves, and particularly to organise. So organise means if you want to talk to government at the highest level, in this case, the national governments are the ones who are held accountable on the international stage, then you've got to get some national connection and unity to take up this task of seeing the declaration implemented. And we're being assisted by the UN in a whole number of levels, except financially. The resources have to be made available, which I think have to come from domestic sources. So Indigenous peoples can organise. We can't operate institutions for governance and well-being if you don't have the resources for that. People have got to go and work in factories or in mines or something like that, which is not helping to get focused on our identity and our futures and our future generations. So I think that's the message I'd like to get across most of all. And if people go to those resolutions that I referred to in the General Assembly and Human Rights Council from the end of last year, I think you'll see a lot in there to motivate you as to, why isn't this happening? Why, what can we do about making those things happen? Thank you.
It's probably at that level on the ground that my work's taken place. Recently, I'm here at Kamragunja in Yorta Yorta country. I live in community and I'm very much placed with my family on country. It's interesting working with the different states, internal states like New South Wales and Victoria. In Victoria, it's strange to know that I think it was the year before, the 2003 or something like that, that they got the Human Rights Charter that came in to being in Victoria. And being a part of the process of the declaration and being very well aware of particularly the clause about the collective rights of us to be able to be in our own polity or our own states. So we've been pushing this concept as Yorta Yorta being a people's collective of a land and country, and trying to grapple with how the Victorian government have been working, because in their charter, they miss out self-determination. It's not a part of the charter. So how do you actually push that whole concept of collective self-determination as in Indigenous peoples, but also the individual collective right as a Yorta Yorta peoples? And that's something that we've been grappling with a lot on the ground. And one of the things that comes to mind is when it comes to Southern Australia, we've got the enormous, conflict or process of trying to say, we are the people of this country. We are the First Nations people. We traditionally own this country. We have the right to be able to have control over our lands, the right to have our resources, but then it's dictated about from the state, whether it's a Commonwealth or the state itself, particularly when it comes to our waters, because it's shared with many states. I'm on the Murray-Darling Basin. And how we articulate those rights has been very arduous. And we have had collective unified groups such as Mildren, the Murray Lower Darling Indigenous Rivers, Indigenous nations, and collective rights of nations themselves. How do you see that process being carried forth in this conversation that we're having now about gaining the states to be able to take that on?
Thanks, Monica. Yeah, it's a good question again. It's why I refer to the lands, territories and resources issue, because you'll notice in the declaration, unlike Australian native title law, it's not based upon continued connection and custom under common law. Self-determination in lands, territories and resources is based upon an historical and traditional connection that happens, and the native title approach that's been used in Australia in many cases about continuing connection and so on is a mislead under Australian duping of its responsibilities to Indigenous peoples. Under international law, there's a right to make a complaint about those things not being recognised. And with the work that I've been doing, I've come to the view that having retired from the international level to work on the domestic level, it's time to step back to the international level and use that leverage that's provided in international human rights law to do things. So what I would do in my state of Queensland is I would make a formal complaint to at least one of the treaty bodies. There's probably three that I would look at: civil and political rights, or the treaty body on economic, social and cultural rights, or the treaty body on race discrimination, to put in formal complaints that the right of self-determination is being denied, while all other Australians enjoy the right to self-determination. Because all Australians do enjoy it, and that is in democratic countries. Basically, the peoples enjoy self-determination because they choose their governments, they elect their governments, etc., and they live according to their rules and standards and so on, but not so the first peoples that were there, the Indigenous peoples that do it. So I'm saying is that my feeling is to upgrade now, not just to complain to the local member or to the organisation meeting that you go to, but in fact to look formal complaints into the international community. And there are a number of places that complaints can be made. And again, I refer back, look at those resolutions that were passed by the General Assembly and Human Rights Council just at the end of last year to see that there is attention to and encouragement of states meeting their obligations. And I'll add there that Victoria, Queensland and Northern Territory and anywhere else within Australia, the obligation to meet our rights as Indigenous peoples rests upon the state nationally. And if there's problems happening, in Australia, the Charter allows certain rights to go to state and territory. The view in international law is that's the responsibility of the national government, and that's what Whitlam said when he took over all the states and territories' role on Aboriginal and Torres Strait Islander affairs and put it into the national level. Because up until then, we had postcode rights. Depending on which side of the border you lived on, you had different rights as Aboriginal and Torres Strait Islander people. We're back to that stage. Depends which side of the border you're on as to whether you have rights, whether you don't.
Yeah, well, Yorta Yorta countries, both Victoria and New South Wales, and that's the problem that we have. Yes, most certainly. I'm sure there's some questions there that maybe want to be asked of yourself. So if you'd like to bring those in, that'd be great.
Thanks, Monica. That's gone really fast. We've only got about 5 minutes left. So I thought maybe I'll just read out one question and yourself, Les, and Monica could maybe give us some thoughts on what you think about it. So the question is, what do you think the state or statewide organisation should be doing to implement the right of self-determination?
Very quickly, I'll give Monica as much time on this. Very quickly, yes, they should be doing as much as they can, but at the end of the day, the obligation rests with the state that is a member of the United Nations, so with the national government. And it's good that states are doing some things, but as Monica said, and the same thing happened in Queensland, they respected our human rights as Indigenous peoples, but fell short of respecting self-determination. And if you don't respect self-determination, you're not respecting any of those rights that are in the Declaration on the Rights of Indigenous Peoples. And we're going to have this problem nationally after this month, after next month, when we hear from the government about how they're looking to have a National Human Rights Act. And again, they're balking at self-determination too hard, they say. So we have to be alert, and that's how we should do them. Monica.
Look, for me, it's most important that we as First Nations people assert our rights. It has to be on a ground level. The education and the which people such as yourself have, and also, you know, I've experienced some of it, is coming back to the ground level. So my choice, of course, is to actually educate our own people. We've got to assert our rights. We've got to assert our self-determination. We've got to assert ourselves as coming from country and having the right and the obligation to our future generations to do that. So I would say that it's a two-prong approach. Absolutely, you can't do with one without the other. It's a grassroots, it's on country, it's being strong in your culture and your identity and who you are as a people, and the work that you've done yourself. And even in the middle, you know, our organisations need to be able to articulate those rights so that they permeate between the mob. And also on the international level, you're very right. You know, it's like you go up and down. And I've had that experience of going up and down, and I think it's really important because you put your hooks in at the international level, then you come back down to your grassroots level and you say, this is there, this is how I wish to interpret my rights, not by what you say, but how the greater, you know, world and the experience of Indigenous peoples as a whole worldwide are pushing. So, you know, it is that we need to grasp onto.
Thank you, Les and Monica. I feel like that's a really good note to finish up on. On behalf of everybody here today, thank you, Les and Monica, for sharing your knowledge, wisdom, experience, the strength that you both have. And thank you, everybody, for joining us today on behalf of DTP and Oxfam Australia. I'm sorry we couldn't get to all of your questions. There was a lot to get through in a short session. This is part of a webinar series, so we will have a couple more coming up, and we will send out invitations to that, as well as the information that was shared with you all today. So thank you very much, everybody, and take care.
Thank you.